Hey guys, it's Gavin here from Sovereign Empowerment, and I wanted to do a quick video for you guys. This is very much off the cuff, purely because I've been getting a lot of messages after Richard Vobes' video and a certain other individual's response to that video pertaining to committal to prison for non-payment of council tax. And what a lot of these people tend to do is they'll give you these facts, and it all looks very real and problematic, and that we're banged to rights, and that is what can happen. But what they tend to not do is also offer the alternative facts that may cause problems with the procedure they're following so as to do that. And that's the key thing in all of this, guys. You've got to remember, we are in tyranny. The rule of law is gone, yet we're using a system that has been subverted and rigged against us so as to fight back. And you might think, well, that seems a little bit redundant. And there are cases where I would say that that is actually redundant these days, but it doesn't mean you can't still get a win. And so specifically with council tax, you don't really want to be challenging the liability to pay because they've sewn that rigged game up completely. But what they haven't been able to do, because it's all a scam, is the procedures that they follow could be proven to be unlawful. And I want to just show you some other facts that these other people tend to leave out, certainly specifically to committal to prison, that change that game if you decide to challenge it. And people do challenge this and they don't go to prison. I'm going to just explain exactly why that doesn't happen if you challenge this in the correct way and you actually understand what's really going on. So I'm going to do a screen share and I'm just going to sort of go through a few pieces of legislation. I just want to sort of set the scene for you so you get an understanding of where I'm going with this one. It's going to be a very simple video. Now, I'm not going to tell you how to fight back with it, but I want to give you these different facts so you can see a very different reality, perhaps to the one that is being put on you by certain other people to dissuade, I think, from standing up for your rights and standing up to tyranny, which is really what this moment in time is all about. Okay, so let me just do a screen share. You guys should see this now. Okay, so I'm showing you first of all the Police and Criminal Evidence Act 1984, because this is applicable to what warrants the police can serve and what they have the authority to act on. And if you were to look at this, I mean, if you were to read this, you'd see a warrant of commitment issued under section 76, sorry, of the Magistrates Court Act. And if you go into this and you think, well, that's screwed then, we're absolutely banged to rights here, you know. But what I'm saying to you is that it's not about looking at that. It's about understanding the procedure that's being followed, because that's where it all falls apart. This is all legit. Fair enough. Okay. You know, you go into the Magistrates Court Act that references, and you'll see the same thing again. You know, oh dear, we can be arrested and go to prison. But what is it they leave out? Well, here's the first thing. As we all know, the liability orders are not court orders. And that was recently confirmed by the Ministry of Justice, and Richard Vobes provided that proof on his channel. Okay. We know that in 2003, the legal forms for liability orders were discontinued. And this basically creates the problem for them, and also the part that we can actually leverage, and actually why Mr. Leighton, with that High Court judgment where he took Bristow and Souter to the High Court, won. They could not evidence proof that they had any authority to act, simply because the liability orders don't exist anymore. And whilst you can get a certified extract of the register, the problem that they've got with that is that these are all bulk listed hearings. They cannot extract your name from one bulk listed hearing that has been given a single case number. You see the problems here for them. Okay, so it's understanding what they're doing and picking that apart, and then confirming the abuse of process and all the other causes of action then come from that once you've notified them of that and they ignore you, which they always do. That's how you get your leverage. Now, this is a statutory instrument. Excuse me. I should be able to put this up for download under the video. There'll be a link for that so you can confirm for yourself. But what else was discontinued in 2003 alongside the legal form for liability orders? It was the warrants for committal to prison. So there is no physical way of proving that you have been adjudged in this situation so as to go to prison. And therefore, the same problem arises. Okay. Now, what this means is that there's no police officer that is going to come knocking on your door to arrest you simply because they don't have that warrant. And therefore, there would be a far, far bigger issue if that was to play out. Okay. So what is it they do? They use the enforcement agents to come and arrest you. And much like these enforcement agents using fake warrants of control to seize goods, now been proven to be problematic in that High Court ruling because they can't evidence anything. Just as a side note, by the way, they can never get those warrants of control because the liability orders don't exist. That's the simple fact. I'm going to take you through a few more bits in just a second, just to gel this together for you, right? To give it some real substance. So the warrants of committal to prison do not exist, and this is why they have to use an enforcement agent. Now, I'm going to come into that in a bit more because think about it. An enforcement agent has no more powers of arrest than you or I to do, okay? It's only the police that can arrest for like criminal matters, etc. Although this isn't a criminal matter either. So there's another sort of thing that's going on here. We're not meant to go to prison for debt matters. But here's another problem. These are the council tax regulations that concern, let me just get it to the original as made for you, that concern liability orders again. Now, this is no longer relevant because they're telling you they've changed it, the original, but the original is still visible here. The latest available revised is here. Now, you need to go through all of the different changes. But the simple fact is this, and I'm going to just read this out. Section 3, the amount in respect of which a liability order is made enforceable in accordance with this part, and I'll jump to the end, is not to be treated as a sum adjudged to be paid by order of the courts. And I'll repeat it. It's not to be treated as a sum adjudged to be paid by order of the court. Well, it begs the question, what the hell is it then? Because that's 99% of the time, certainly in a lower court, that's what you're going to court for. You're either the claimant for some sort of debt matter or you're the defendant in some sort of debt matter. But at the end of that hearing, there's a judgment. And if you've lost, you have been adjudged, there you go, to pay the debt by order of the court. This is telling you that that is not a real hearing because nothing is being adjudged there, which is why they can't produce the liability orders and why they had to remove the warrant of committal to prison, because it's not a real hearing. And they're telling you in this. Now, it's any wonder why they're changing this legislation as people like us tend to wake up to these things and start using it against them. It's a very inconvenient truth for them, so they change it. But the reality is, do you think that them changing this means that that isn't real? Of course it's not real. It's still the case. So if it's not being adjudged as a debt, they can't get a liability order, which have now been confirmed to be not court orders. They can't get a warrant for your arrest because the only ones that can serve it are the enforcement agents. And given that judgment that we've just had, which even though they didn't win on the harassment case, that doesn't mean that we can't, okay, because the judgment now exists. And if they can't do that, do you really think an enforcement agent can come to your property and serve a warrant, a non-existent warrant, so it's a provably fake warrant of arrest or fake warrant of commitment to prison? So what's really going on is, in our ignorance, in that situation, we turn up to that hearing and we're incarcerated. And what's really happening is we're voluntarily walking ourselves into that very situation. If you didn't go to the hearing and they came to your property, you can just tell them to, go away because they can't arrest you. They have no power to arrest you. And given that judgment, they've got no power to enter your property. They literally can't do anything here, guys. It's a non-event. So let me just stop the screen share. I want to walk you through now some important factors as pertains to the enforcement agents trying to do this. Okay, there's way more going on here, but I just want to keep this focused to the warrants for committal to prison. Okay, and I want to just show you I'm going to show you a summons, a fake summons for this. Okay, guys, so what I'm showing you here is quite a heavily redacted summons, but it's a fake summons for committal to prison. And you've got this fake court crest here. I mean, look at it. It looks fake. Red writing is what the enforcement agents do. This is fake. There's no name or signature of a court agent. And whilst they have changed the rules there to say they don't need a wet ink signature, they very much do need a name of an agent that's seen it. Okay, and it really does need to be the justice of the peace, although they can try and get around that stuff. But this is fake. This is not a real summons to a committal hearing. So why give it any energy, right? They can't do what they're doing, and you can sue these people for doing it in their personal capacity. That's the way to win. So you can see there, that's it. That's the summons. No signature, no nothing. No one's applied their mind to this at all. And we can see why, because despite the legislation saying they can do it, there are major flaws and gaps in that legislation in how they do it. And that's the problem. And that's what you can use to leverage and push back on it. Okay. It's all just a load of crap, to be frank, guys. You can just look at all of this stuff. Absolute rubbish. All right. So there's your fake committal summons. And what I just want to do now is I just want to touch on really the issues that the bailiffs have got, or sorry, not the bailiffs, the enforcement agents. And in fact, there's a correction I need to make for myself, and just to put you guys right on that. A lot of people say bailiffs, and it's really important that we have a distinction between them and the enforcement agents, because they are not bailiffs. Bailiffs do have some power from the High Court, right? But these goons are not coming from the High Court. They don't have any of that power, and that judgment now confirms that, certainly with council tax enforcement, for enforcement agents specifically. Just to come in, that doesn't it doesn't mean all enforcement is sorry, it's not a case that you can use for all enforcement of council tax. Although the same facts apply, they can't provide any evidence of anything ever happening in the court in your name. So once it's handed to a third party, that's where it all fails. That's where you should be putting your energy in. The court agents become liable in these situations. That's how you basically push back. So really, just to wrap this very quick video off, the forms don't exist. It's the same problem with their liability orders. Once it's given to a third party, that's where it fails. So this is why police do not get involved in serving any of those types of warrants, because they're not real. They couldn't do it. It would be a huge problem if they did. And this is exactly why the enforcement agents get involved. So now you know the truth. If you've got a goon at your door trying to arrest you, are you really going to voluntarily give yourself away and go to prison? It's ridiculous. You can sue these people. If you had an agent at your door trying to arrest you, you could put them in prison for what they're trying to do to you. Okay? They have no real court documentation. It's a scam. So with that said, guys, hopefully that's cleared up any misunderstandings about committal to prison. Yeah, the legislation's there. Yeah, it looks like it's all above board and it can be done, but it fails in the procedures and the way they try to do it, simply because the sum is not adjudged as a debt in the courts. The forms for the warrants don't exist alongside the liability orders, and personal liability is where you want to get these people from. Okay, you got negligence, you got breach of every single time with council tax is a breach of due process. Absolutely provable. That's one cause of action to get them on. So once you make this personal and you start attacking them based on what they're doing to you, do you think you have leverage to start shutting this stuff down? Absolutely. The Ministry of Justice is your friend. They manage the courts. They're there responsible for the behaviour of the court agents. Don't fight the council, people. Focus on the weak links. It's the court itself, okay? The council people, or the head of revenues, if you like, if they are a target, they become liable by default because they're overseeing the whole thing. You come to them last. Letter before action. You'll shut the whole thing down. All right? So hopefully this video helps. Please leave me some questions and comments in the video below. Sorry, this is a bit impromptu. You can see I've not shaved or anything. I just thought I'd just do this one. I had a bit of time, so here we go. There's the video. I am going to put one together for charging orders, because it's the same principles, actually quite straightforward to deal with. I'll give you it now, but I will go into more detail in that other video. You're going to get an interim charging order first, and it will confirm in that order it's not been in front of a judge. This is how they're getting away with this scam. It's completely administrative, but you do have 28 days to object. And what they're planning on with this stuff is that you don't know how to object, okay, let alone the basis of how you're objecting to it. All you need to do is file an N244, hearing in person, human rights, Article 6 of the European Convention for Human Rights. You're allowed a fair and public hearing. They have to give you that. Now you're in front of a judge. N244, full disclosure, I think it's CPR 34.14, if memory serves me right. I will do a full video on this. Full disclosure. How are they going to disclose something that you already know doesn't exist? This has been the problem for the Bristow and Souter in that other High Court case, right? They can't prove that you have been adjudged against. And the problem then is that the solicitor that they're using, because what they like to do is they use a witness statement of the solicitor as the truth under penalty of perjury, and that's what the judge is then using as their facts, their decision on, basically. But if they can't disclose the facts, as in you've been adjudged, then that solicitor's running a very dodgy game for themselves, a very precarious game, because perjury comes into play, doesn't it? They become a liar because they can't produce the evidence that anything actually happened to you in court. And so the charging order would fall away. It's all the same thing, guys. The procedures themselves kill it because they're not lawful. And that's the key point. So I'll do a proper video on that one as well. Hope you've had a great Christmas. I'll catch you on the other side in the new year. See you soon. Bye-bye.